Aam Aadmi candidate for Ponda by-election. काल ते ऑब्जेक्शन कित फायल केल्ले ते आम बरोवन ऑब्जेक्शन दिल्लें कॅन्डिडेट आमचो डॉक्टर केतन भाटीकारान बरोवन ऑब्जेक्शन दिल्लें आनी हांव तें वाचतां की आतां तुमकां कळों जाय कितें बरयल्लें आनी कोणें कांय फोट मारलो ना हें म्हणलां आय एम रेजिंग ऑब्जेक्शन टू द वॅलिडिटी ऑफ द नॉमिनेशन फॉर्म ऑफ श्री गितेश नायक एज अंडर. Number 1, Gitesh Naik has filed an affidavit wherein he has suppressed the fact that an FIR in CR number 0348 of 2025 dated 15/7/2025 under sections 316 into bracket 2, 318 into bracket 3 and 3 into bracket 5 of the BNS Act 2023 have been registered at Kengiri Police Station, Kengiri Subdivision, Bangalore City, Karnataka, wherein Gitesh Naik is the accused number 1. Second paragraph. Gitesh Naik has knowledge of this FIR as he has obtained a copy thereof and filed criminal writ petition number 721 of 2025 F, which is filing, in the Bombay High Court at Goa, challenging the FIR. Copy of the writ petition along with the FIR and other documents annexed to the writ petition are enclosed. Third, the law requires complete disclosure to be made as this is the right of voters to know the antecedents of a candidate for elections. 4. Gitesh Naik is facing an FIR for offence relating to criminal breach of trust and cheating as of date which he has suppressed. 5. Suppression is different from making a false statement. 6. The voters ought to know that Gitesh Naik is accused of criminal breach of trust and cheating is out in the open as a candidate for the current by-elections. As this is a suppression of fact backed by unrefuted material placed before you and not mere fact of false statement in the affidavit file, the nomination form of Gitesh Naik needs to be rejected. Ata I copy of writ petition pasun lailoli. Then writ petition file kelti high court and te writ petition tene FIR ची कॉपी लायल्या थिंगा एट पेज 32 आणि पेज 32 दाखयता तो FIR कर्नाटका पुलीस स्टेशन रजिस्टर जालो आणि तो सेक्शन दाखयता हांवें वाचले ते क्रिमिनल ब्रीच ऑफ ट्रस्ट आणि चिटींग आणि हांवें सुप्रीम कोर्ट जजमेंट सगळें वाचून दॅट फॉर प्युरिटी ऑफ इलेक्शन्स हें जाय म्हण काल ताका रिप्लाय करूंक जायना आसलें आनी टायम मागला आनी 5 म्हाका दिसता तेणी आरोप रिप्लाय दिला आमकां दिलो ना सकाळीं आमी हियरिंगाक गेले तेन्ना म्हाका रिप्लाय दिला आनी रिप्लाय कॉपी तुमकां सर्क्युलेट करता तुमकां वॉट्सॅपाचेर धाडटलो रिप्लायान तो मानून घेता हें इम्पॉर्टंट तो मानून घेता की हांव वाचतां तेगे उतरां हो रिप्लाय तेजो फायल केलो तो तेणें सायन मारला तेने technical pleas गेले that this is not a ground for rejection. Mere registration of FIR without charge being framed is not a suppression. सगळे technical grounds गेले. But important, म्हाका कित important is. In the present case, it is alleged that an FIR number charge, no charge has been framed. The FIR itself is under challenge by me in criminal writ petition number 721 of 2025 before the Honorable Bombay High Court at Goa. No charge sheet is filed, no cognizance and no summons is issued. म्हणलो आमी कित गायले ते डॉक्युमेंट गायले ते आमी फॉल्स डॉक्युमेंट गायले ना आमी फोटींग पॉयंट काय म्हणलो ना आमी दाखय आहा ते दाखयला आनी तूं मानून घेता हें करेक्ट म्हण आमी म्हणलं तें आतां हिशोब कितें सेक्शन हुंचे आहात ते आतां सेक्शन BNS एक्टाचे ओल्ड सेक्शन 420 जाता 420 चिटींग आनी 406 क्रिमिनल ब्रीच ऑफ ट्रस्ट सो आतां हें आहा जाल्यार म्हणलो तो मानून घेता की FIR रजिस्टर आहा कर्नाटका तेजे चिटिंगाचे आनी क्रिमिनल ब्रीच ऑफ ट्रस्ट तो मानून घेता की आमी ऑब्जेक्शन ऑन फॅक्ट्स काडले ते सामके आसा म्हणलो काय मी फोटो मारलो ना आनी रिप्लाय तेजे कितें दीस इज नॉट अ ग्रावंड फॉर रिजेक्शन तें वेगळें ते आमचें पळोवपाक जाता वी कॅन सी लेटर ऑन वेदर दॅट डिसिजन ऑफ RO इज रायट ऑर रॉंग that will be seen later in an election petition as and when it's required, if at all he wins an election. Today we can't challenge that order, it remains. आता एज फाटल्यान ऑब्जेक्शन हांवें काडटा तेन्ना हांवें पासून उपरांत एक सांगलोलें की FIR राजस्थानान रजिस्टर केली. FIR राजस्थानान रजिस्टर केली ती हांवें म्हणलोले पासून ते FIR नंबर 187 ऑफ 2024 आनी ते सेक्शन आहात ते 420 चिटींग आनी 406 क्रिमिनल ब्रीच ऑफ ट्रस्ट. एका उतर ना, हें फोट्यो म्हूण ना, हें फाल्स म्हूण ना, डॉक्युमेंट आसा मोकडे. सो आतां हें सेकंड. हेज भायर हांवें कितें म्हणलोलें, एक नोटीस येयल्ली म्हूण हेचे कित्याचे टाटा कॅपिटल हावजींग फायनान्स तेणें तेगे पोजेशन तेगे बाटाचें पोजेशनां घेवपाक तें नोटीस काडलेली. हांवें तें दाखयलां आनी हिंगा म्हणटा अमाउंट एंड डेट ऑफ डिमांड नोटीस एज ऑन 14/12/2023 एन अमाउंट ऑफ ₹38,18,413 तें देणें म्हण एंड डेट ऑफ पोजेशन 27 May 2024. Right or wrong, whether you agree or you don't agree, you challenged or you don't challenge, these are documents I am putting in public domain for you to know. So मुगे क्वेश्चन कितें, एक पाटी हांव डॉक्युमेंट दिता, तूं वय म्हणटा, उपरांत तुमच्यान कितें कोण म्हणून जाता, काँग्रेस पक्ष डॉक्टर बाटिकार आनी आमी फोटी मारतात म्हूण. दिस इज कंप्लिटली रॉंग. आय कॅन अंडरस्टँड that you can say irrelevant objections, you can say something else, but you can't say ami photo matale. This is a complete lie, not only of people who have made this statement, but even on behalf of the party it was being made that this ami photo male. Magi आता फकत कॅन्डिडेट न्ही, तेंचे पक्षाचे लिडर आहात ते जातीचे उलोवपाक लागले. हांव जातीचें कांय म्हणना, कितें आमी गोंयकार तूं जाणा, आमी जात धर्म केन्ना चोयनात. आमी गोंयकार म्हूण पळयतात आनी गोंयकार म्हूण आमी वयतात फुडें आनी आमचें लायफ डेली तेशेंच आसा. हांव तुमी जाणात की हांव सगल्यांक बरो आसा, हांव केन्ना कोणाको डिफरन्स करना आनी हांव केन्ना चिंतना कोण म्हजे फुडें येयलो हे धर्माचो ते कास्टाचो तेश कोण केन्ना केस जाल्या नाल्यार काम जाल्यार हांव सगल्यांचें काम करता. म्हूण म्हाका एक हें बरें लागना की हे एक विक्टीम कार्ड म्हूण करूंक सोदतात, दाखोवपाक की आमी तेजे फार मारूंक सोदताले आनी तांकां काबार करूंक सोदताले. तुमकां सांगलां तेणें की तेणें कितेश नायक आम आदमी पार्टीचो तेणें एक आदवोगाद हाडलेलो, गोंयकार न्ही तो, म्हाका दिसता तो कोण भायलो, हांव कांय वरना ताका. आयिल्लो तो स्पेशली रितेश रवी नायकाचे फॉर्म ऑब्जेक्ट करपाक. आज तूं भंडारी समाज म्हणटा जाल्यार तूं कोणा हाडटा रवी नायकाचे फॉर्म ऑब्जेक्ट करपाक. ऑब्जेक्शन काडला, तो आयल ना तुगे डिफेंड करपाक, तो चुकून आशिल्लो की हांवें ऑब्जेक्शन काडलो आशिल्लो थिंगा, तूं येयला हेगे ओपोज करपाक. ऑब्जेक्शन काडला आनी काल पासून म्हणलेलें ऑब्जेक्शन काडलें, ओवररूल जालें आनी रितेश रवी नायकाचे फॉर्म एक्सेप्ट जाला. सो एश कोन्न तुजें डबल फेडूंक जायना. तुमचें तें इसरोवन तुमकां खबर ना कितें जालें तें आमगे रिटर्निंग ऑफिसर फुडें, कोणा धाडला त्या मनशाक, पक्षांनी धाडला ओ हें हाडला, हांव नेणा म्हूण हें आसपा जाय. आनीक एक सांगूंक सोदता हांव तुमकां, आयज हांव वयता तेन्ना रिटर्निंग ऑफिसरान फुडें फॉर द लास्ट हियरींग म्हाका वाटेर कोण आनी कितें धाडला म्हूण आयज तो पॉयंट काडूंक जायना. आनी कायद्यांनी हांव तुका सांगता, तुगे एफिडेवीट ऑन एसेट्स, ऑन युअर प्रॉपर्टीज, ऑन युअर बँक बॅलन्सीस फाल्स आहा जाल्यार इट इज नॉट अ ग्रावंड फॉर रिजेक्शन ऑफ अ नॉमिनेशन फॉर्म. देखून आमी तें केन्ना काडनात. तुगे एक बँक अकावंट चुकलो, तुवें पयशे दाखयले ना, तें आमी ऑब्जेक्शन काडलो ना. सुप्रीम कोर्टान डिफरन्स केला बिटवीन सप्रेशन ऑफ क्रिमिनल एंटिसिडंट्स वर्सीस नॉन डिस्क्लोजर of assets or filing false affidavit about assets. So देखून हांवें तो आर्ग्युमेंट फर्स्ट पार्टाचेर केल्लो. आयज हांव म्हणटालो वाटेर आशिल्लो तेन्ना म्हाका आनी कोणान हें धाडलां की लोकमान्य मल्टीपर्पज कोऑपरेटिव्ह सोसायटीन एक आर्बिट्रेटरा फुडें केस घायल्ली आनी थिंगा 5 जाणां रिस्पोंडंट म्हूण आहात. एक गितेश गोकुलदास नायक, एक अभिजीत आनंद शिरोडकर, एक बोनावेंतुरा डिसोजा, एक रोमा गितेश नायक, एक सुधीर त्रिलोकनाथ दुबे. आनी हेंचेर सगळ्यांचेर opponents 1, 2, 3, 4, 5 shall jointly and severally pay to the disputant Lokmanya society a sum of rupees 22 crores 97 lakhs 4,802 together with interest at the rate of 22% per annum and additional penal interest at the rate of 2% from 16/1/2019 till date of complete realization of the amount with cost of rupees 1 lakh within 30 days from date of this award. मागीर म्हणल्यार दॅट यू कॅन एग्जिक्यूट इट म्हणून. आतां 22 कोटी 97 लाख म्हणल्यार ऑलमोस्ट 23 कोटी देणे. लोकांक खबर आसपा जाय न्ही. सुप्रीम कोर्ट कितें म्हणटा? सुप्रीम कोर्ट म्हणटा लोकांनी सांगूं जाय म्हण कॅन्डिडेट सगळें डिस्क्लोज करून लोकां फुडें वचपा जाय. वयता तेन्ना हें क्लियर आसपा जाय की कितें केस आहा, तुगे एसेट सगळे तूं लोकांक लिपोयता जाल्यार आनी दाखयना जाल्यार मुगे मनान कितें हांव चिंता एक कोण कॅन्डिडेट हेच सोड तूं खंयचो कॅन्डिडेट गेलो जाल्यार आनी तो सामको रिणां बुडलो जाल्यार आनी ताका पयशे नाय जाल्यार इलेक्शन कितको झगडटा लोक चिंतलो. पयशे कोण दिता, पयशे खंयसून हाडटा आनी मागीर पयशे कितको रिकवर करतलो, तेगे लोन कितको फारीक करतले, लोक चिंतलो हें सगळें. देखून सुप्रीम कोर्टान सांगलां लोकांक कोण दी हें सगळें. बरें तूं सामको गरीब जाल्या पासून कॉन्टेस्ट कर पूण लोकांक कोण दी. लोकांक सांगनासतना इतलें रीण आहा तेन्ना तूं इलेक्शनाक वयता आनी बसता आनी तूं सांगता आमी फोटो मारतात, हांव डॉक्युमेंट दितां, मुगे डॉक्युमेंटा भायर हांव कांय उलयना. देखून हांवें म्हणलां हें सगळें आमी सांगलें तें सच सांगलां. आनी आनीक एक वाचूं वयता तुका तें एफिडेविटाचें फॉर्म आहा अशें. एक स्टेटमेंट नंबर 5. I am not accused of any offences punishable with imprisonment for 2 years or more in a pending case in which charges have been framed under me by the court of competent jury. हें आसा. सो हें आहा थिंगा एंड सो सगळे हें हाडूं जाय कितें in which charges have been framed by the competent court of competent jurisdiction. आतां हें सगळें हांव म्हणटा केन्ना हूंय कोण वयत जाल्यार आमी पासून कितें एक FIR आहा जाल्यार पासून आमी डिस्क्लोज करतात FIR आहा म्हणून. FIR ना जाल्यार तूं क्लीन आसा म्हणल्यार तुगे क्रिमिनल रेकॉर्ड ना जाल्यार दाखोवपा जाय. लोकांक कोण दी कसली केस दी. तूं लोकां पासत झगडपाक गेला, रस्ता रोको जाला, तुका लाठी चार्ज जाला, तेन्ना मागीर तुजेर FIR घायल्या, हें लोकांक कळटलें. म्हूण फायनान्शियल ट्रान्जॅक्शन आहा तेन्ना पयशाचें खबर आहा जाल्यार आनी थिंगा चिटिंगाची केस आहा, लोकां देणे म्हूण तूं चॅक बाउन्सिंग तूं दाखयला नो प्रॉब्लम, तूं लोकां देणे जाल्यार आनी थिंगाय केस घायले मागीर लोकांनी चिंतूंक जाय. आनी ते सुप्रीम कोर्ट म्हणटा लोकांक खबर आसपा जाय कसलो कॅन्डिडेट म्हूण आनी मागीर कसलो कॅन्डिडेट इलेक्शनाक बसता म्हूण आमी मत दिवपाचें ओ मत दिवपाचें न्ही म्हूण इतलेंच.
तुम्ही म्हणले FIR disclose करू ना. Is it mandated to disclose the FIR?
See, when the Supreme Court wants criminal antecedents to be disclosed, then it is my contention that all your, if you don't know, I can understand. Sometimes एक FIR कोण फायल केलो तूं पुलिसीन केन्ना आपयलो ना, you may not know. Understanding what it is. But when you know the FIR, you are challenging it in court, then you have knowledge. Then you can't say, I don't know. See, the fact is not, FIR is known or not known. The question is it a fact that there is an FIR or not? You understand? There is, no? And there is a case of what? 420 FIR asa. So that is important. That is what we have to see.
Altogether, how much loan you have taken?
हांव एक सांगता तुका आनीक एक हांव देखून हांव म्हणटा हांव डॉक्युमेंट नासतना बेश्टोक एक कांय म्हणा म्हाका आनी कोणें आनी कितें सांगलां कितें आनी कितें आसात म्हूण तेचे पूण अंटील आय व्हेरीफाय वीथ फॅक्ट्स हांव म्हणटा कितें सेंटेन्स स्टेटमेंट करचना I don't want to sensationalize it. I don't want to make statements which are wrong and based and keep it in speculation. That I will not do. If I'm, as of now, there is, I think, in his affidavit, he has said about 22 lakhs already decrees against him. I think about 22 lakhs, 17 or 22 lakhs. That is subject to correction. Then, what I have seen here is, in Lokmanya, he is owing, not of Lokmanya, that Tata Capital, he is owing 38 lakhs 18,413 with interest. I don't know from which date it is coming, but that notice is of 2024. And Lokmanya case, which is a notice of 2021, of the order of 2021, shows 22 crores 97 lakhs 4,812. So this is what it is. Such huge amounts. Maybe sometimes somebody has a huge windfall and he can just pay in one installment. Maybe, I don't know what are the means how people can pay. But sometimes I think also when you get money, half will go for income tax. It's such huge amounts. So you have to get really very huge amounts so you have to be able to pay this. Because it will be above 50 lakhs and then you are going to be 50%. You understand how the taxation works. So 50% goes for tax. So what will remain for you to pay is what remains. If these are the only loans.
वेन्झीन एक स्टेटमेंट केला की आमकां फक्त एकूच ऑपॉर्च्युनिटी दी म्हणून 8 म्हयन्यात प्रूव्ह करपाक.
So Venzi should have. First thing is, you all rightly asked the question to Captain Venzi that you all are supposed to be in an alliance. So I think Captain Venzi should have spoken with our leaders before fielding the candidate. So I can't make a statement on that because that is my party will reply. But personally, I feel that we all need to be together because we have one common enemy. The common enemy today for us is the BJP. So my statement is, anybody who wants to defeat the BJP stands with us. Anybody who is not with us definitely wants to defeat us and make sure that BJP wins.
With this highlighting of this issue, were you expecting disqualification of the nomination?
We put up our case and we definitely expect the best. And if we don't get a favorable order in our favor, which sometimes we have also not got all favorable orders, we have gone to the higher courts. So I've said that option is still available in the event he should win. But I would like to get this tested. Let me be honest with you. It's not for A or B or this case. It is for purity of elections. I would like to get this tested. Because Supreme Court uses this word, that we need to clean the system. And I will just tell you the words which I had read today. I actually give me a moment and I'll show you exactly. This is a judgment in Civil Appeal 13015 of 2024, Ajmera Sham versus Kova Lakshmi, Supreme Court judgment. And this is what I'm going to read for you, just the last part. Paragraph 11 I will read for you. Judicial intervention in election disputes concerning disclosure of information as discussed above was prompted by the quest for sanitizing the electoral process by eliminating polluting elements by making candidates' criminal antecedents public. Aiming to prevent criminals from participating in elections to maintain purity of the election process, the essential for proper functioning of parliamentary democracy, the court was compelled to, in its extraordinary power, to issue specific directions. Consequently, not only the disclosure of criminal antecedents, but also related obligations to disclose assets, liability, and education qualification election candidates becomes mandatory. The knowledge of the criminal antecedents, assets, and education qualification of the candidates by voters certainly invigorates the electoral process, which is ensured by obligatory disclosure by the candidate. However, see this, the court has made a subtle distinction between non-disclosure of the criminal antecedents and that of the assets of educational qualifications. While disclosure of criminal antecedents in the electoral process was the most critical element to maintain the purity of electoral process, which has to be scrupulously adhered to, disclosure of assets and educational qualifications were considered as attending supplementary requirements to strengthen the electoral process, of which there will be certain scope for consideration as to whether it is of substantial or inconsequential nature. So this is what the Supreme Court says. That's what I'm talking. When you talk of purity of elections, this is how it works.
Today Aam Aadmi Party asked for the apology from your side for doing the allegation on the debatation.
Have I made any false statement? If I make a false statement, I'm the first one to apologize. If I have not made a false statement, then I think they have not understood what I have said. I think they have not heard. And sometimes ki zyada लोक आहा बेश्टो म्हणपाक की हेणें एशें म्हणलां मागीर दुसरो चाडोता आनी कितें म्हणटा. So sometimes you should not jump to making statements and asking for apology. Sometimes that is, I look at it politically like a strategy, just to browbeat, lokak photopak, ki false statement kela. And you see, I saw somewhere that Congress is peddling lies. How can you be lies? I've told you the truth. I've shown you documents. So on what should one apologize? I can understand. I'm ready to say apologize if I've said something wrong. 420. Cheating, 420, I'm munta chor mun. What else is there? Have I said anything wrong? Have I showed you any false document? Have you said any document is false? Have you said that what statements I have made are false? See, maybe after 2 years, maybe after even 6 months, maybe next day also, maybe this case may be quashed. I don't know. I'm not coming on that. Today, the question is on the day you file the nomination, what is the status? That is the law. Thank you.